SJC-12102, Jacqueline D. Snow v. Winthrop E. Snow.
Ms. Hennessy, good morning.
Good morning, Your Honor.
On behalf of Mr. Snow.
I am here on behalf of Mr. Snow. May it please the court, my name is Bridget Hennessy of Donovan, O'Connor, and Dodig. I'm here with my colleague, Buffy Lord, representing Winthrop Snow in his appeal of the Berkshire Probate and Family Court judgment of modification dated May 4th of 2015. The issue before this court today is it relates to the Alimony Reform Act and the provision in the Reform Act for durational limits on marriages that are under 20 years. In this case, the specific issue is when does the duration begin to run? The trial judge determined that there was Ms. Snow was entitled to a duration of 179 months of alimony. And the question that we're bringing to this court, and our position is that that term of 179 months should have begun at the date of judgment of divorce.
Whether or not alimony was decided at that point?
The parties were divorced in New York State at the Saratoga Supreme Court. The husband had filed the complaint for divorce. The wife had counterclaimed for alimony.
But she defaulted.
She defaulted,
We
and
don't know anything about the circumstances that she was in at the time, do we?
we do not.
But I guess just as a matter of common sense, how do you have an award of alimony that has a certain duration start running from a period of time when there was no award of alimony?
Well, Your Honor, our argument is that the Superior Court in New York State did issue an order. They ruled on the issue of alimony.
But that's different from an award of alimony.
That's
it's
correct.
a non-award of alimony. I mean, the statute doesn't say a decision about alimony. It says an award of alimony, doesn't it?
The statute actually doesn't
Or
say
it just
when
uses the word alimony. Well,
That's
there
right.
wasn't any alimony in the New York State judgment.
But the issue was before the court. The New York court made a finding on it, and
Well-
it's contained in their judgment of divorce.
So your view is that the statute says, quote, general term alimony shall continue for not longer than 90% of the number of months of the marriage, and your argument is that the judge essentially found that general term alimony shall be 0,
In New York.
In the
New
New
York.
York, yes.
and that therefore the order commences upon the finding that general term alimony shall be 0.
That's right.
And is it and why would the legislature do that?
The reason why, Your Honor, is because the history of alimony in the Commonwealth of Massachusetts, then and now, is to provide need for spouses who are economically dependent and on the payor's ability to pay. The history is that it was impossible to determine a recipient spouse's future need, and what happened as a result of that is all alimony orders in the Commonwealth of Massachusetts were perceived to be a lifelong obligation. It bred reliance. It put recipients in positions where it was unknown to them if suddenly they were going to abruptly face a termination because of a significant change in circumstances of the payor. And the purpose of the Alimony Reform Act was to provide consistency, clarity, and predictability. The goal of the Alimony Reform Act is for recipients and payors to be able to move forward with their life, be self-supporting at some particular point in time, and so that people could plan for things such as retirement, and payors could
Doesn't
see.
this all assume the payment of alimony?
I'm sorry?
It's all presuppose the fact that alimony's been ordered and paid?
That an alimony order has already been made?
Yes.
I don't believe it does, Your Honor, because if you look at the language in the statute relative to the cohabitation piece, what that piece of the Alimony Reform Act says is that if at the time of judgment of divorce, a recipient spouse is receiving alimony and at a later point in time cohabitates, that the alimony can be suspended, terminated, or modified as a result of that cohabitation, and then if the recipient spouse ends her or his cohabitation, seeks further alimony, that the term is not extended. So that period of time when the recipient spouse is cohabitating, that durational clock is ticking, and there's no alimony being paid. There's a similar provision in the Act that does the same thing when there is a dual child support and alimony obligation. The Act says that the maximum term that somebody can collect cannot be extended beyond either what they could collect in child support or what they could collect durationally.
But there's no such language in connection with the beginning point for durational alimony in connection with general term alimony, right?
That's correct, it
So that
doesn't say.
We
So
look to see what the other sections, but that cuts as much against you as it does for you. Could I just ask you, I want to be clear about this. You're basically saying that in all cases, general term durational alimony starts with the date of the divorce judgment, irrespective of whether or not that divorce judgment has anything to say about the subject of alimony. I mean, because we know that there are statutory provisions that permit later complaints to be brought for alimony. It doesn't have to be settled in the original divorce. So you're saying irrespective of whether or not the divorce judgment addressed the subject of alimony at all, that's when durational alimony still begins to run.
That's right.
Don't you find that a peculiar thing in the face of the statutes that permit, the statutory provisions that permit alimony to be decided at a later point?
No, I don't find that to be inconsistent. It's consistent with the legislative intent of the Alimony Reform Act, is to provide economic support to a dependent spouse when they are most dependent, which is going to be immediately following.
Maybe
Not,
yes, maybe no.
yeah.
Not in this case, but when you were listing the purposes of the Alimony Reform Act, one of the purposes was to have a presumptive limit of how long there would be alimony. And you're saying that if there's no alimony initially, nonetheless, you start the alimony clock running.
That's right.
But the point of the statute was to have a durational limit, an amount of time of alimony.
Or, on the other hand, it could be a period of time in which if a spouse is in need, the spouse is supported so that that spouse can become economically independent. That is the goal. The goal is foreclosure, because otherwise payors can't see the light at the end of the tunnel. The presumption is that alimony is a lifelong obligation. You may be able to legally terminate your marriage, but you can never terminate your financial responsibility.
But that's not what
for
the
a spouse.
statute says, right? There's durational limits, and so there will be light at the end of the tunnel at some point. My question to you is, say the durational limit is 90 months, and the wife comes 85 months in because she's fallen on hard times and needs alimony. So she only gets 5 months of alimony?
I think that the only way that there can be consistency in the application of the durational limits is for those limits to start immediately upon divorce, because you can think of a number of hypothetical situations that the outcome is going to be different, but the duration, if you calculate the duration under the statute, that durational period is going to be the same. But it's the events that take place during that could result in one payor paying the entire duration versus another payor paying 50% of that
That's
duration.
only under your view of the statute, though. If you look at it as the durational limit begins when alimony is paid, then it's going to be that 90 months no matter when it starts.
Well, that's true.
Okay.
But how is it that there can be any predictability in
But
any
of course,
end?
doesn't the statute provide discretion to the trial judge?
It does, absolutely.
That goes against the argument that there's always going to be exact predictability and in how much how long the duration's going to be.
But the opportunities for the judge to issue a deviation of the duration are set forth in the statute.
But do you think this fits under, is this under section 49E? Is that what you think we're under? Where do you think this order is coming from? Is it a modification?
The order in this case?
Yes.
The order in this case is a judgment on a complaint for modification. It's a
So
judgment of modification.
Is it governed by 49E?
May I have a moment? Yes.
And that 49E as opposed to 49, the ones that you've mentioned about child support and about, I mean, this is a point the judge made, and cohabitation doesn't say anything about putting in the limits, does it?
I'm sorry, could you restate that question?
For example, 49, the cohabitation one is which one? It's something 2, D2, right? 49D2? That's the cohabitation.
Yes,
Okay. And it says, shall not extend beyond the termination of the original order, right?
correct.
Okay. Then you march down to the next paragraph, E, and it just doesn't say anything about how long. So if the judge is modifying, I guess I just wonder, seems like the judge could set it.
But I think that so B is the section that provides for the durational limits. It has to be read in conjunction with E. So in E, even on a modification, which is what happened in this case, the trial judge issued that durational order. He determined what the duration is. So the duration still applies.
And nobody's arguing about the period.
Nobody's arguing
duration.
about the period.
Can I ask you, though, whether or not this is a modification? I couldn't really tell what the judge was doing here, because I don't see any finding of material change in circumstances.
We do not dispute that there was a material change in
Well, I
circumstances.
understand it, but the judge didn't make a finding for it. So, I mean,
He didn't
he
make
really
a-
sort of used the Section 34 factors rather than Section 37.
He didn't make a specific finding, but the overall interpretation of his rationale, which included his findings, is that there was a change in
And
circumstance.
what would the change in circumstances be? We don't know anything about her circumstances in 2010 at the time of the New York State divorce when she defaulted.
I think that there is testimony in the transcript that she was residing in a marital home that had been foreclosed upon
In 2010?
in 2010.
It had been foreclosed upon then?
It was actually foreclosed upon in 2008.
So what were the material change in circumstances? She was in sad shape then.
She was in sad shape then. At the
And she was
time,
presumably then in the same degree of need of alimony than she was later.
but we don't know that for sure because she
So
defaulted and
That's
didn't
what's so
appear.
difficult here. I don't understand what the basis for a material change of circumstances is if you don't know what's changed.
And at the time of when the wife filed the complaint for modification, she was living in her vehicle and dependent on the Commonwealth for some form of support. So we didn't dispute that there was a change in circumstances. And going back to the issue about whether this is a modification or whether this is an original complaint, other than the material change in circumstances, the analysis is the same. So substantively, it's not different.
Well, from your position, it's not different, because you're saying it doesn't matter whether
That's
it was an
correct.
original complaint or it was the modification, because it's the divorce judgment itself that starts the meter running.
That's correct.
Let's discuss briefly the temporary alimony and the inclusion of that in the
Yes, Your Honor.
179 months. I mean, I understand if there had been an award of alimony and the judge had changed it, that you would start, well, date would go back to the original award of alimony, but where no alimony was awarded and the judge is trying to ascertain the appropriate amount of general term alimony, why would, under Holmes, the award of temporary alimony start the clock?
Because in Holmes, this court stated that what you need before general alimony can begin is you need a judgment terminating the marital relationship. That's the judgment of divorce from July of 2010. So once the judgment of divorce is issued and the marriage is terminated under Holmes, so the difference between the facts in Holmes was it was a complaint for divorce and a temporary order of alimony under Section 17. Then it went to judgment, and the duration counted from there.
But that was because you couldn't get a general term alimony until there had been a judgment.
That's right.
And here there had been a judgment, but no general term alimony. So in terms of the
But there could have
writ of
been.
Holmes, why, there could have been,
Sure.
but there wasn't. So why would, as a judge tries to figure out what the amount of general term alimony should be where where there had been none before, why would that start the clock any differently than, well, I mean, I guess you're arguing because this was post-judgment as opposed to pre-judgment. That's what you say to be the distinction.
Right, it's post-judgment.
Okay, thank you.
Thank you.
Ms. DeSantis, good morning.
Good morning, Your Honors. May it please the Court, I'm Lindsay DeSantis for appellee Jacqueline Snow, and with me today is Attorney David Sanfloni, also counsel for Jacqueline Snow. So my appeal was with regard to three significant issues, and the first you've touched upon is whether an alimony award that had not been previously awarded in a judgment of divorce commences the durational limit at the time of that judgment or later on the first commencement of the first issuance of a judgment. Go ahead.
You filed this as a modification, right?
Well,
Isn't that the title of the pleading?
it was, Your Honor, but I'd like to
But
point
you're
out.
really bringing it under 34?
I did not. If as the pleadings show, our client was pro se at that time, and she filed a complaint for modification of a foreign judgment on her own.
So if you had been there from the beginning, what would you have filed
A complaint for alimony.
under Section 34?
Absolutely, Your Honor.
Okay.
And I think that the difference.
And that's how we should treat it, in your view?
I do. I think that that's how we should treat it, and I think that that's how the trial court
Well,
judge
the trial
treated it.
judge was
Not
sort of
clear.
vague about what this really was. The trial judge wasn't so clear about what he was doing.
He wasn't, Your Honor, but he never referred to Section 37 in any manner.
Referred to section, but he did refer to it as a modification. And that's what, in fact, why he did what he did with respect to starting it as of the time of the temporary alimony award. So it's not really clear what the judge was using to decide whether it was original or a modification. But look at the New York award regarding alimony, which is a $0 award. Under Buckley, doesn't that really sort of make this a modification rather than an original complaint?
I don't believe so, Your Honor, and I believe the facts of Buckley were there was a complaint for divorce, and then there was an agreement for judgment, wherein there was no order of alimony. So there was an opportunity at that point.
Where the parties agreed that they were going to leave it open for the future.
Absolutely. So it was addressed. It was addressed at that point. It was understood by both parties in an agreement for judgment that alimony was reserved for the future. So when you've reserved it, you've addressed it at that point in the underlying divorce.
Well, the judge in New York addressed it. He certainly addressed it.
She addressed it, Your Honor, but I think if you look at the judgment and also the rationale that was provided there, she addressed
In
it.
New York?
In New York.
Yeah.
She addressed it solely with regard to saying there's no maintenance. She didn't reference any factors. She didn't talk about any reason for maintenance. And if you look at the financial statements that were filed in New York, as well as the financial statements that are filed here in Massachusetts 4 years later, Ms. Snow's financial statements are all zeroed out. They're all nominal amounts. She didn't have any assets or income at that time or here.
So I thought that the New York order, though, said it specifically did address it, that there would be not be any, right?
It specifically says there is no award for alimony. No maintenance is, there were two separate times. So
No
there was
maintenance is required, or something like that?
I believe the specific language in one was no alimony is ordered, and then in the rationale or the findings, it said no maintenance is awarded.
So,
But each time it did say none.
so let me see if I understand this. The general rule that you want is that it begins, the durational clock starts running with the award of alimony originally?
With an initial order,
With
yes,
an
Your
initial
Honor.
order. So if we were to disagree with you and say that this was really a modification, then it would still start running as of the time of the New York.
Well, I don't think so, Your Honor. Again, when you look back at the,
We thought that Buckley was dispositive and that the judge had addressed alimony in the New York judgment. On the rule that you want, it's not the date of the divorce, it's the date that there was an initial award of alimony. And if we're saying that that does count as initial award of alimony, then that's the date that it starts running.
if you thought Buckley was dispositive, absolutely. But I think that that flies in the face of the Alimony Reform Act and the alimony, even the archaic alimony statute that we had on the books for some time. The basis for alimony has always been to support a recipient in need. And again, based upon the payor's ability to pay. So when we're cutting something so short and we're not providing alimony, how is that equitable? So the principles of family law in general are all about equitable, rational, logical decisions supporting families, supporting a husband or a wife, depending on who's the payor and who's the recipient. So the purpose of the alimony statutes is to provide that support. And if it hasn't been provided, how is it triggered?
Let me ask you another question, though, in terms of the the legislative intent here. Because an original complaint for alimony could be brought subsequent to the divorce, if the duration is, say, 10 years, but it's brought 11 years after the marriage has ended in a divorce, the payment of alimony will go on for a really long period of time, well past the time that would have been possible if alimony had been awarded at the time of the divorce. Doesn't it strike you as intention, at least, with the legislative intent to bring alimony to a close?
No, I don't, and the reason being is because although that the purpose of the Reform Act was to provide some guidance, where before we didn't have a way to calculate alimony, now we do. Before we didn't have a way to calculate duration, now we do. It still provides some type of discretion for the trial court judge in all of this. And specifically under the modification, it calls for deviation, it calls for deviations, it calls for modification of amount and duration of the orders. So there's still discretion there that's always left to the trial court judge. And I think if there's facts that they find there was a 10-year marriage, maybe 11 years later, a recipient or a possible recipient brings a complaint for alimony, he or she is going to look at that fact pattern. What happened since the time of divorce to the date of this complaint for alimony? Is it just and is it reasonable to award alimony now at this time? What's the change in circumstances? And there's an ability to order or not order. And I just
Well,
want
that's true in this case. That's actually true in this case, regardless of how it's interpreted. The judge could find that there should be a deviation beyond the durational limit, even if the duration started at the time of the New York divorce.
Absolutely, Your Honor. Again, pointing out, these are presumptive limits. They're not set in stone. There's always deviations that are allowable, and there's carve-outs. So there's specific carve-outs, as you spoke about before, for cohabitation. And the legislature actually specifically wrote in that when there's a carve-out for cohabitation, that doesn't stop the clock on the durational limit once it's been triggered. The same thing with when alimony and child support has been ordered concurrently, that the clock doesn't stop at any point. So they addressed these things specifically, and I don't think that, and again, going back to the purpose of the alimony reform and the 14 months that it took this task force to address this comprehensive statute, they specifically added in all of these carve-outs. And I think that when you look at that and there's an omission, it's not accidental, but that's intentional.
So you're saying that if the judge in New York had said you get $1 per month for alimony, that the clock would have started with that?
Absolutely.
But because the judge said no alimony, the clock only starts when there is the actual imposition of an award of alimony.
I do, Your Honor. And the reason for that is the fact that whether it's $1 or whether it's $100,000, the amount is inconsequential. It's an amount. that was ordered, that was awarded. Plain language of award is to be given something. None is not given anything.
So you were just making the distinction between this and child support combined with alimony or cohabitation period of carve-out. Do you say, though, that the durational limits apply and all we're talking about is when they start, or do you say they don't apply? I'm trying to figure out whether, if you call this a modification, your position would be that the judge can set the durational limit independent of the durational limits that are in the statute.
Well, the judge always has that ability under.
Well, I know, but that's by making specific findings.
Yes.
I'm just wondering whether this is just different. You don't.
Well, I think that because of the discretion that's allowable, every case in family law is always brought on a case-by-case basis by the specific facts, and that's the reason for the discretion.
But the presumption is that the alimony, that the duration limits will apply, however it's brought.
Absolutely. So if a modification is brought, then that means an actual award of alimony was given previously. So whether that modification is brought to extend the alimony, to limit the alimony, I mean, now we've seen many complaints for modification for alimony to terminate in light of retirement, in light of many reasons, in light of a change in circumstances as far as a loss in income, a disability, things of that nature.
Okay, but just to be clear, it wouldn't, in your world, it does not matter whether you call it a modification or an original action. The key triggering point is the affirmative award of alimony.
Absolutely. And I did cite numerous cases in my brief that show that when a complainant has brought an action under the guise of a modification, but it was the first time alimony was addressed, that really it should have been addressed under Section 34 and not 37, and that it's okay, even though it was brought under the guise of a complaint for modification, to actually address it as it should be addressed. And there's support for that in my brief.
Now your sister says that temporary alimony should be treated as general term alimony when it's done post-judgment, and therefore the judge was correct in starting the clock with the award of temporary alimony.
And I disagree, Your Honor. I think Holmes was very clear. Your Honor's just decided that case 2 years ago. And even in that case, I
But it
believe...
wasn't post-judgment, was it?
No, it was not post-judgment.
Wasn't that what Holmes was about?
Well, Holmes was about, again, when the durational limit starts. And in that case, when you're talking about fairness and what's equitable and reasonable, there was a temporary order in that case, and I believe, correct me if I'm wrong, but 2 years, 3 months, and 24 days that payor was temporarily ordered to pay alimony to the recipient. And he wasn't credited at all for 2 years, 3 months, and 24 days. So if you're going to take that into consideration, and I believe Holmes also said that the only way that the temporary alimony should be taken into consideration is if it's been for such a lengthy time and it's due to the recipient's purposeful prolonging in order to then receive that temporary alimony and then basically tacking it on to the duration is the way that I read it. That wasn't done here. We had a temporary order that was given in January of 2015. And then we had a final judgment in May. So there was about 3.5 months of temporary payments. That was all. So there was no prolonging by our client whatsoever. And in fact, there was really a nominal period in which temporary alimony was provided at all.
And you say, assume everything else, that at whatever the duration, sort of goes with alimony, goes health insurance or looking at it, right?
It is, and when you look at the at 208 Section 34, the statute uses shall quite a few times in here. So, and it specifically says when the court makes an order for alimony on behalf of a spouse, said court shall determine whether the obligor under such order has health insurance or other health coverage available to him through an employer or organization, or has health insurance or other health coverage available to him at a reasonable cost. Down below, as it goes on, it says said court shall, which mandates include in the support order, which was not done here, even though it was pled, it was argued, and it was requested in Attorney Sinfloni's and my proposed rationale. The support order a requirement that the obligor do one of the following. First, exercise the option of additional coverage in favor of the spouse. Second, require that payor to obtain coverage for the spouse, or 3, reimburse the spouse for the cost of health insurance. So it's not necessarily just the fact that
You
they're-
have to address it, and the fact that it isn't available through your employment doesn't get you off the hook.
it's not enough. It's clear here that there are 3 options that can be given, and just the mere fact that it's not available through your employer doesn't mean that they're off the hook. And particularly in a case where you have a gentleman who has, $1 million in assets, and you have somebody living in their car who had been physically abused by this payor, eating dog food for months, he has the availability and the means to pay for this health insurance.
So but you're saying more that the court must consider it. You're saying the court must give it. The court must
It
order
must make an order, one way or another. It needs to address it.
But are you saying the court simply may need to address it and say, under these circumstances, in view of the alimony award, I'm not going to order health insurance? Or is it your view that the judge must order health insurance pursuant to the last sentence, as long as there is coverage available to him, which under the Affordable Care Act probably applies to everybody?
It does, Your Honor. I mean, the statute is a statute, and the language specifically mandates that shall include in the support order one of those 3 things.
I take it that in the circumstance, if that is correct, that the judges then calculates, can the judge consider the cost of that as part of what he or she is doing with respect to the alimony, the dollar amount?
I believe so. I mean, there were 2 factors to the amount of alimony that can be awarded. One is based on the need and ability to pay, but then also there's the big or there, again, 30 to 35% of the difference between the parties' incomes. And again, there's the discretionary use of the judge.
So let me just make sure. I mean, with this, I assume this language was enacted before we had the Affordable Care Act, and before Massachusetts had its Affordable Care version?
That I don't recall, Your Honor. I believe...
But you're saying today, in view of the entitlement, or in view of the availability of health insurance for all, that every time there is a divorce, the judge...
must take it into consideration,
Well,
and it can be
you're
part
saying
of the
more than that.
award.
You're saying the judge must make sure that both husband and wife have health insurance.
Well, it doesn't address whether husband or payor has it. It addresses...
Could a judge in this situation, where you've got the payor has some capacity, but presumably at least at the moment, and I'm not clear why she hasn't, but the payee or potential payee certainly could qualify for Mass Health and, in fact, Medicaid, right?
I agree, absolutely, Your Honor.
So could the judge say she needs to get Mass Health?
I believe so. That could be an order. It could be addressed in order that she qualifies for Mass Health and should apply therefore. But
And
unfortunately,
then-
with an order of $810 a week, which is attributable income to her under the tax guidelines, she then, I don't believe, would qualify for Mass Health.
So then you would say you have to do this, okay.
Okay, thank you.
Thank you, Your Honors.
We'll take our morning break.